Look, I know that you're a member of the Attorney General's Review Committee on Capital Cases, and you've litigated cases involving issues related to the death penalty. I know that the death penalty is far more common at the state level than the federal level, but as President Trump has now issued the executive order allowing the use of the death penalty when in criminal cases in federal, when authorized and appropriate under the law. Can you explain how the use of capital punishment differs from federal court as opposed to the state court system, and discuss your role on the Attorney General's Review Committee and what all that entails?
Hey everyone, welcome back to the channel. Today we're looking at something unusual, a Senate Judiciary hearing that didn't devolve into cable news theater. No shouting, no ambush lines crafted for Twitter clips. Instead, what we saw was a rare moment. A nominee to one of the most powerful seats in the federal judiciary being questioned with actual seriousness, and answering with clarity about what kind of judge she intends to be. And here's why that matters. Federal judges don't trend on social media. They don't campaign. They don't go on TV. But they hand down decisions that shape sentencing, rights, power, and precedent for decades after the politicians asking them questions are gone. So when you get even a small, unfiltered glimpse into how a potential judge thinks, how she weighs punishment, how she interprets law, how she understands the limits of power, that matters more than any viral confrontation you'll see from Capitol Hill.
Thank you, Mr. Chair, and happy birthday. Thank you for being here. Appreciate your willingness to answer the call to service. You have an incredibly impressive career. To your children that are sitting behind you, guys, your mom is a boss. Yeah. Pretty incredible. And so thank you so much for your willingness to do this at a time where I think our nation is grappling with what it means to be in the public eye and stepping up to serve. In addition to that, thank you for your willingness to do that at the highest level. Looking at your background, obviously clerking for then Judge Kavanaugh and Justice Scalia, immensely impressive in addition to your courtroom experience. I'd like to know, through that courtroom experience that you've had, is there a particular case that you've worked on that you believe is the most formative in your career, and how is that going to help kind of inform your work on the bench?
I think the most formative case for me in terms of especially my Seventh Circuit practice was an en-banc case called United States against Page. And Page concerned the standards for convicting people of conspiracies to traffic drugs. So these are the more serious drug traffickers who we prosecute in the U.S. Attorney's Office. And in Page, what we urged the Seventh Circuit to do was actually to overturn decades of its own case law that had sort of bit by bit, case by case, gone awry and deviated from the Supreme Court's guidance about the meaning of conspiracy. And we achieved that result successfully by doing essentially very deep research into the Seventh Circuit's case law, and then presenting our arguments forcefully but respectfully when you're asking court to overturn many of its cases. And we succeeded, I think beyond my wildest expectations, garnering the vast majority of the court to, I think, adjust its case law in the manner that we asked it to do so.
When you're looking at the then Judge Kavanaugh or Justice Scalia and that experience that you had, is there any particular case or moment that where you were in discussion, dialogue with them, anything that you feel like will be formative to how you conduct yourself when you're on the bench?
As a law clerk?
Yes.
As a law clerk, I think the most formative case that I helped with was the Affordable Care Act Obamacare case. Obviously, the rules of confidentiality and clerkships preclude me from saying too much about that work, but it was a huge case, and I was privileged to get to work for Justice Scalia on that.
Excellent. Look, I know that you're a member of the Attorney General's Review Committee on Capital Cases, and you've litigated cases involving issues related to the death penalty. I know that the death penalty is far more common at the state level than the federal level, but as President Trump has now issued the executive order allowing the use of the death penalty when in criminal cases in federal, when authorized and appropriate under the law. Can you explain how the use of capital punishment differs from federal court as opposed to the state court system, and discuss your role on the Attorney General's Review Committee and what all that entails?
Yes. So each state, of course, has the authority to decide for its own self the penalties that are attached to its most serious crimes. So some of our states have the death penalty and some do not. And, in practice, as a result, there are far more executions in some states than in others. The federal government, by contrast, of course, has a uniform rule across the United States, and there are a reasonably small number of federal crimes that are eligible for the death penalty upon conviction. Within the Department of Justice, the decision of whether to seek the death penalty in a particular case is an extraordinarily weighty one that goes all the way up to leadership. And in its path up to leadership, there's something called the Review Committee for Capital Cases, which is a set of DOJ attorneys who review the cases that are eligible for the death penalty and make a recommendation that goes to department leadership about whether to seek or not. And so it's a careful process that's really case-specific and that, always keeps in mind the extreme weightiness of that work. I have, as you mentioned, led the appellate litigation team for 2 federal executions, and that is among the weightiest and most serious work I have ever done. And so I take that extremely seriously.
Absolutely. Well, I just want to say thank you for your willingness. Are these your parents here? Yes. As well? You've got to be so proud. I mean, her command of the issues, her knowledge, and the way she conducts herself with class, integrity, is amazing. When you see somebody go toe-to-toe with our colleagues up here, it's amazing. And I also wanted to say thank you for your commitment to Senator Moody of conducting yourself with collegiality and civility, and the way that you approach things on the bench.
Thank you.
Her answers, cautious, careful but revealing, exposed not just legal training, but worldview. You could hear how she thinks about responsibility. You could hear what she believes the bench demands from a person. And you could hear between the lines what kind of rulings she is likely to write over the next 30 or 40 years. This wasn't a gotcha moment. There was no microphone drop. What we got instead was rarer and more valuable, a glimpse into judicial power before it becomes precedent.